Hello everyone and welcome to new video of editorial part from the Hindu newspaper. I hope you will enjoy this video. Let's move on the newspaper editorial section. You can see on my screen today our topic is the lower judiciary litigation pendency stagnation. Constitution bench of Supreme Court of India, headed by the Chief Justice of India, recently linked the sense of stagnation in the subordinate judicial service to prolonged litigation and the huge pendency in India's court. According to the National Judicial Data Grid, there are 4.69 crore cases pending in district court. Another bench of court has asked judge in Delhi to undergo training due to lack of basic knowledge. There are a few options to make changes in the administration of justice. The Code of Civil Procedure and the Civil Rules of Practice contemplate procedures to be followed by the courts in entertaining proceeding, issuing summons to the defendants, and for the appearance of parties. Subordinate judges handle this. They are forced to call every suit for appearance of party, ordered the issue of fresh summons, and receive. This takes up much time in the morning, leaving judges with very little time for the disposal of cases on merit. In most subordinate courts, the calling of cases goes on from 10:30 a.m. till well past noon. Quality time is lost by attending to such clerical and ministerial work. A judicial officer in the lowest rank in hierarchy can be appointed in every district court to call all the cases of that particular cadre of courts. Senior civil judge or civil judges or district munsif as the case may be. This court can do ministerial work the whole day and can also be assigned with the power to record per ex parte evidence, issue of summons, receiving wakalat, and written statement. At the end of the day, this court can list matters for trial and the argument the following day in each court. This list can be posted on the basis on the website in the morning. The cases can be taken up as is in is as in this list from 10:30 a.m. every day by each court, and these courts can dispose of matter listed till evening can be still dictated, thus helping in judgment and case disposable. The subordinate judiciary quality. There was time when lawyers who practice law under the tutelage of reputed lawyer in any branch of law with at least 10 years of experience in the bar used to be appointed district munsif magistrate. Lawyer with more experience may also qualify after appearing for examination for direct recruitment as district judge. But now judges are appointed without any experience and find it difficult to cope with the workload. In many cases, there are a number of judges who don't even pass order as they are not occupied. Therefore, every civil judge or senior civil judge who is appointed must undergo training with different high court benches for a few months and observe how a high court function, how high court judge hear matter, interact with lawyer, go through the judgment seated and study how order are passed. This work culture of by observation is the step that will definitely improve the working of the subordinate judiciary. Whenever a state whenever statute is passed, new provisions are introduced per purportedly for the quick disposal of case. but in many cases results are not achieved for expeditious disposal. On the contrary, there are a negative impact in example typical example in section 12A of the commercial code as act as act and its provision making pre-suit mediation mandatory. The Supreme Court, while interpreting section 12A, has held in Patil Automation versus Rakheja Engineer 2022 7 MLG 139 that this provision is mandatory and that the plaintiff plaint is liable to be rejected without pre-suit mediation. In commercial cases, parties who are in business who have already exchanged notice only where exchange of notices don't result in settlement to they resort to legal proceeding in court. Therefore, at the time of filing the suit, it would be known where the matter is headed. So, where is a need to make meditation mandatory and direct the plaintiffs plaintiff to exhaust the remedy of meditation before filing the claim. Another example is the 6 month cooling off period in marriage laws in filing for consent divorce. The parties concerned often want to disposal of case within the period once a couple decided to separate or mutual term. A pertinent issue is on whether they should be forced to wait for 6 months. Some courts don't allow this cooling off period to be dispensed with, leading to further proceeding and pendency. It is not known if it is wise to have a 1 year separation in filling a mutual constant petition, while the same is not applicable in the contested petition. An untrue declaration is made by the parties, making it out as if they have been separated for more than 1 year to move a petition. Some of these provisions result in pendency and also the litigant facing frustration. A third example is the new Rent Act. There is enough confusion already as to whether the absence of a written registered lease can vest the rent court with jurisdiction in conflicting judicial opinion. Armed with the same set of facts, one can approach a civil or a commercial court in the case of commercial lease, but not rent court. These anomalies could have been avoided had the legislation accepted oral lease as well as delivery of possession recognized by the Transfer of Property Act as before. In the case of lease of residential properties and small apartment, parties don't want to spend on stamp duty and registration fee for lease. The nebulous state of affair created through status is another reason for tendency in court. Archaic procedural law. A number of provisions in the Code of Civil Procedure have also become a tool for some litigants to delay proceeding. These provisions are misused, for which there are many examples. For instance, why should there be preliminary decree and final decree in partition action? Why cannot one decree be passed? Dividing the properties or order to sell under the Partition Act soon after the passing of the decree, even if two decrees are contemplated by should not the final decree proceeding by an automatic continuation of preliminary decree without a fresh application causing delay. Similarly, executing execution proceedings are not easily terminated because of many provisions under Order 16 of the Court, which can be used by the judgment debtors to delay the process of execution. For example, why should there be 103, 106 rules under Order 16, many of which are hyper technical, unless drastic steps are taken to modify the procedure and compel parties to provide why and means to satisfy the decree if passed in due course, even at a stage of framing and the list of assets by disclosure are made. A citizen will be forced to visit court for a year to realize his decree. This will be his plight in respect of all money claim, including arbitration award passed in this favor. There is a need to simplify the process of the execution of decrees and awards, and it is here that fast track procedure is needed. What is important is the quick termination of the proceeding, not merely the conduct of trial or further proceeding by way of appeal. The code might have served the purpose when it was passed in 1908, but it is unfortunate that even after amendments in 1976 and 2002, there is still no solution to have the proceeding concluded expediency. An example is Amendment to Order 8 Rule 1 CPC making it mandatory for defendant to file a written statement within 90 days. The plaintiff the plaintiff can gather detail for a year to file the suit. What happened in the written statement is filled within 90 days. The suit is still not disposed of immediately and the trial takes its own course, especially when the right to appeal is exercised by the aggrieved parties. So why have time frame only for filling the written statement? This provision has not helped the cause other than its resulting in self-sought pleading. While the time frame is fine when it is about money claim, it does not work in title suits. Pendency and the higher judiciary. The issue of there being huge pendency need to be addressed by the higher judiciary. Also, the termination of judicial proceeding within a reasonable time, not a hasty approach to proceeding when it is common sense or it is work in progress. It is urgent need solution to reduce pendency ought to be considered unless we give up archaic laws and recruit competent lawyers as judges. We cannot expect the qualitative qualitative disposal of cases, nor will pendency reduce. The subordinate judiciary should be allowed to function as judges and not be ministerial court officer ordering the issue of fresh summons, receiving and pleading the calling cases and writing notes on the dockets of nearly 2 hours every day. So I have completed this first editorial part from the Hindu newspaper. I hope you will enjoy this video. I want to say one word or one line or one sentence. I am trying to give my best, so I'm not perfect. So it's my starting phase. So you get too much mistake or wrong pronunciation in this newspaper. So I am trying to improve my skill or reading skill and learning skill and understanding skill. That's why I am reading newspaper daily. Thank you so much for this video. We will meet on another video.